Welcome to The Explainer. Today we are diving into something really fascinating, the Islamic perspective on crime. We're unpacking a framework that totally challenges the Western legal norms we're used to, and we'll see how it actively shapes the living, breathing statutes of modern-day Pakistan. This perspective doesn't fit neatly into the traditional Western theoretical boxes we've explored before, which makes it a deeply intriguing topic to dig into. So, right off the bat, where exactly do we draw the line between a sin and a crime? Usually in the legal frameworks we study, we think of a sin as a moral failing that's judged by God, and a crime as a clear-cut legal violation judged by the state, right? That line usually stays pretty firm. But to truly understand the material we're covering today, we have to look at a system where that line operates completely differently, a place where the theological and the legal are just deeply intertwined. Okay, let's map out our journey for this explainer. First, we'll look at the foundational rights distinction. Second, we'll cover Hudud, Qisas, and Tazir. Third, we'll explore agency and repentance. Fourth, we'll see how this is all codified in Pakistani law. And fifth, we'll compare these criminological frameworks. Let's get into it. Section 1, the foundational rights distinction. All right, to really grasp this foundational distinction, we've got to completely dismantle our usual Western mental model. The one where we categorize crimes simply by how severe they are, like grouping things into felonies and misdemeanors. Here, the entire legal structure is organized based on whose right was violated rather than the inherent severity of the act itself. So on one hand, we have hukuk Allah, the rights of God. These are violations against the public interest and divine command. And because God is considered the offended party in a legal sense, the state absolutely cannot waive or pardon these offenses once they're proven. On the other hand, we have hukuk al-ibad, the rights of people. These are violations against a specific individual's life, body, or property. And because a person is directly wronged here, that individual or their legal heirs retain a massive role in the resolution. That actually includes the power to forgive the offender or accept compensation. It's a total paradigm shift. Moving right along to Section 2, Hudud, Qisas, and Tazir. So, that core distinction of rights we just talked about, it directly dictates the three primary classifications of punishment within the system. Let's start with hudud, translating to limits or boundaries. These offenses fall strictly under the rights of God. We're talking about acts like theft, highway robbery, and unlawful intercourse. Now, judges have absolutely zero discretion regarding the punishment here. It is completely fixed. However, because these punishments can be incredibly severe, the system imposes an exceptionally rigorous evidentiary standard. You would need multiple credible eyewitnesses or a completely clear confession. The logic is actually pretty brilliant. If the punishment is non-negotiable, it demands near absolute certainty of guilt before it can ever be applied. Next up is Qisas, which means retaliation. This applies specifically to offenses against a person's body or life. Think physical injury or even murder. It functions on the core principle of proportional retribution, literally an injury for an injury or a life for a life. But here's the wild part. It introduces a profoundly different mechanic that actually removes the state as the sole arbiter of justice. This really illustrates how Qisas operates in the real world, because Qisas falls under the rights of people, the victim, or their legal heirs, hold the actual authority over the final outcome. They have three choices. They can demand that proportional retaliation, or they can opt for a financial compensation, which is known as diyat. And, remarkably, they can also choose to simply forgive the offender entirely, walking away without taking anything. It literally hands the ultimate power of resolution directly to the wronged party. Then we have our third category, Tazir. Think of this as the broadest, massive catch-all category. It covers any offenses that aren't explicitly addressed by hudud or qiyas, or it's used in cases where a hudud offense definitely occurred, but that incredibly high, near impossible standard of evidence just couldn't be met. Here, judges actively use their own discretion to determine the punishment, weighing things like the severity of the offense, the offender's background, and what's needed to maintain public order. Okay, Section 3, agency, intention, and repentance. With those punishment categories said, we've got to ask, how does this theoretical framework actually view the mind and the agency of the offender? Well, the crucial point is that this framework emphatically affirms free will. This concept is known as taklif, meaning offenders are held legally and morally responsible because they actively chose to do what they did. But it doesn't just apply this bluntly across the board. The system places massive legal weight on niyyah, which is the offender's intent. Plus, mitigating factors like being a minor, acting under duress, or lacking mental capacity due to insanity heavily alter a person's accountability. It looks really closely at the individual's actual capacity for responsibility at the exact moment the act occurred. And here's where it gets incredibly unique.
It actually formalizes Toba, or sincere repentance, right into the legal framework. This isn't just some personal, spiritual matter you do in private. And some historical rulings regarding those strict Hudud offenses, genuine remorse and a real change in behavior occurring before the case is brought to court can actually alter the legal outcome. It reflects a system that holds very strict boundaries, for sure, but simultaneously blends deterrence, retribution, and genuine reform, rather than treating them like they're entirely competing goals.
Section 4. Codification in Pakistani law. So, how does all this pure legal philosophy actually look in the active modern laws of Pakistan? Well, the implementation begins at the absolute highest level, the Constitution itself. Article 2 declares Islam as the state religion, and Article 227 mandates that all laws must conform to Islamic injunctions. But Articles 203 through 203D are where the real muscle is. This establishes the Federal Shariat Court, granting it the power to actively examine and strike down any laws that are repugnant to these injunctions. Actually, it was this exact court back in the 1980s that declared parts of the Penal Code repugnant specifically for failing to include Qisas and diyat, which literally forced Parliament to rewrite the laws.
If you're studying this for an exam, this is basically your ultimate cheat sheet. You can clearly see how directly all of this translates into the Pakistan Penal Code, or PPC. That Qisas and diyat framework was injected directly into Sections 299 to 338 back in 1997. Section 302 covers intentional murder, while 310 and 323 govern those compensation routes we talked about. It's also super important to note the 2006 Protection of Women Act, which pulled rape and zina out of the super strict 1979 Hudud framework and put them back into the ordinary PPC under Sections 375 and 376. That was a huge move because it eased the strict evidentiary burden on victims. Understanding these specific statutes shows that this isn't just history, it's a live working legal system that enables the real-world legal compromises and forgiveness cases you see in the press today.
Finally, Section 5. Comparing criminological frameworks. So how does this entire Islamic framework actually stack up against the Western criminological theories we've explored in other explainers? Well, compared to the consensus theory, Islamic law definitely agrees that law reflects a shared moral order. But it totally bypasses the idea of Western social evolution by rooting that order strictly in divine text. Next, compared to the classical school, think Beccaria and Bentham, it shares that really strong belief in free will and rational accountability. However, the classical school has absolutely zero equivalent to that rights of God versus rights of people distinction. And interestingly, it serves as a strong rebuttal to conflict theory, because in this framework, punishments are meant to be based strictly on the act itself and the evidence, completely without regard to an offender's wealth, status, or social class. Which leaves us with a pretty incredible final thought to wrap up this explainer. When the ultimate power to forgive a severe crime, like murder, is handed directly to the victim or their family rather than the state, are we witnessing a higher, more evolved form of restorative justice? Or does it simply reduce the justice system to a high-stakes legal negotiation? It's a profound difference in legal philosophy, and it fundamentally changes how a society approaches crime, punishment, and the rights of the individual. Thank you so much for joining me, and keep exploring these incredible legal paradigms.